So just a few questions. So it's my understanding that this is a state density bonus project and that we don't have discretion to mandate that it be made smaller or shorter or anything of that sort, correct?
That is correct.
Okay. Can you talk a little bit about the Snowball case and how, if at all, it applies here?
Sure. Snowball looked at a different issue. It wasn't really about the findings that are at play today, whether we can meet those high thresholds to deny density bonus, right? Very specific qualitative adverse effects on health and safety. Those thresholds are the ones that are really at issue here.
And it's the determination of the city attorney's office and the planning department that evidence doesn't exist that would allow us to grant the appeal.
That is correct. There's no evidence in the record that would ever give us the ability to deny these density bonuses.
So I also understand that the state's Housing Accountability Act includes a provision that if the applicant challenges the city's denial of the project, so if we were to vote to grant the appeal today, we would be required to award not only attorney's fees and costs of the suit, but also a per unit fee of up to $50,000 per unit, which would equal $2.1 million for this project. Is that correct? I know we get letters from the state sometimes when we deny projects, basically saying you're going to be liable.
Yes, that calculation is correct.
Were any technical studies submitted by the appellants to contest the city's prior project approvals?
No technical studies have been submitted by the appellants to contest the city's prior project approvals.
Based on this conversation, I just want to be clear. Is there any substantial evidence in the record to grant this appeal?
No substantial evidence was submitted by any appellants.
Okay, thank you. So I just want to say to my constituents, I get it. There's a lot of density going into places in our city that are already very dense. I live in a multifamily neighborhood, and that's where a lot of the density is going based on changes in state law. And I've encouraged this community to go talk to their state representatives about how state law changes are affecting our communities, because we don't have that discretion anymore. And I hear from people who are very frustrated by that, and I share that frustration. So there's not much we can do here today, which is to say, I don't think there's anything we can do here today. I think that the applicant has worked very hard with the community to try and get it to a place where it's less impactful than it was at the outset, and I'm grateful for that. So the state has come in and decided that we don't have local land use authority over lots of things anymore, and we just don't, and that's frustrating for constituents who want the city to be standing up for communities in the way that they like, and we just don't have that authority anymore. So, colleagues, I'm asking that we deny the appeal, because it doesn't seem like we can grant the appeal. I think this is a good project considering. It's not what all the community wants, but I'm asking that we deny the appeal because I don't see that we have a choice.
All right, I will call the roll. Mr. Harris-Dawson?
Yes.
Ms. Yaroslavsky?
Yes.
Ms. Padilla?
Yes.
Ms. Hutt?
Yes.
4 members and unanimous.
Excellent. We are adjourned. Thank you so much, everybody.